Justin Lum for Fox 10 Investigates here with Russ Richelsoph, on the record, criminal defense attorney not associated with the Lori Vallow Daybell case, but we wanted his take on the latest motion filed by the so-called Doomsday mom. She has filed a motion to dismiss her case for a lack of a speedy trial here in Arizona. Just to catch you up, she's charged with two charges of conspiracy to commit murder in the death of her former husband, Charles Vallow, and in the attempted murder of her ex-nephew-in-law, Brandon Boudreaux. This really starts at the beginning of the Lori Vallow saga in 2019. Russ, first off, thanks for joining us. And what do you make of Lori Vallow Daybell's motion?
She actually did a pretty good job of writing the motion. She was concise. She cited the law. So I think as far as the motion goes, she wrote a good motion. I don't think the judge is going to dismiss the case, and that's because the way that time is computed and the situations in the case where time is waived. So when her defense attorneys asked for time, asked for continuances, that time doesn't count. And then the time that she was going through the competency evaluation, that time also does not count. So I don't know what the new time computation would be once you exclude that time. But judges can go over the speedy trial time for exceptional circumstances. And it's not unusual in cases that are this complex for it to take more than the usual 270 days to get the case to trial. So what I suspect will happen is I suspect that the judge will set a trial date on the second case, but I expect the judge will deny her motion.
Yeah, she is claiming that her Sixth Amendment right has been violated. And you spoke a little bit to that. I mean, is there any truth to that? I mean, you bring up the point that there's been some time elapsed because of the mental competency evaluation and the motion for the continuance by her former team. So yeah, there has been a lot of time that has gone by. But again, this is a complex case. Is this something normally that a defense attorney may do to say, hey, you have violated my client's Sixth Amendment right? I mean, does it seem like she knows what she's doing here?
So yes, defense attorneys will sometimes insist on a speedy trial and try to get the case to trial within the time limit set by the rules. Usually, though, that I would say that's the exception. Usually, the focus of the defense attorney is having enough time so that they can provide an effective defense for the defendant in a criminal case. So it's more important to the lawyer to be adequately prepared, to have time to interview all of its witnesses, file any motions that, legal motions that need to be filed, and get rulings from the court on those issues rather than rushing the case to trial. There are circumstances where we do want to get the case to trial quickly, but usually that's a strategic move. If we think that there's an advantage to getting the case to trial sooner rather than later, or if we think the state just won't be able to prove the case and the defendant's sitting in jail while the case is pending, that might be another reason why the defense will want to push the case for trial quickly. But normally, defense attorneys are going to want more time to be more adequately prepared.
Yeah, because as we know, this is a voluminous case, terabytes of discovery. There's a lot to go through. So for any new defense team, they definitely need a lot of time to prepare. But who knows this case better than Lori Vallow Daybell herself? I mean, she is literally at the center of this case. But should she be, for her own good, take a step back and not try to rush this? She's indicated she wants to get this going as soon as possible.
I don't know why she is in a hurry to get this case to trial. Probably because she's sitting in jail, and jail isn't a pleasant place, and prison. She is facing prison up in Idaho. Prison tends to be better than jail. So usually defendants in criminal cases who expect that they're going to be found guilty or who are facing a prison sentence want to get to prison more quickly just because the living conditions in prison are better. There's things to do in prison. They have more, they can have a job in prison. So it's, the days filled with doing something. It's my understanding that she's representing herself in this case. I never would advise a defendant in a case this complex to represent themselves. When a defendant represents themselves, they are essentially treated like an attorney would be treated. So they're expected to know the rules and the laws, just as an attorney would. And that can get really tough in court because there's a set of rules apply in court called the rules of evidence. And these rules are tough. I mean, it's even tough for new lawyers to understand and have a good mastery of these rules. For a lay person, it can be really difficult to understand why, if they ask a question of a witness in court and the prosecutor objects, it can be really difficult for a layperson to understand why the judge sustained the objection. Like, what's wrong with the way that I formulated this question? And it can be really technical. So it's difficult when a defendant represents themselves just because they're expected to, follow all of the rules of evidence and, know the statutes, just as an attorney would. So I generally do not recommend people represent themselves in court. I would expect she knows the facts of the case and, she knows what really happened, but that's not really going to help her necessarily in court because, oftentimes the defense is trying to poke holes in the state's case and prove that there's reasonable doubt, convince the jury that the state hasn't met their burden of proof and hasn't proved this case beyond a reasonable doubt. And it can be difficult to do that when you're too emotionally tied to the case and you're kind of hyper-focused on the facts that, as you think they happened, but, maybe there's a different explanation for the evidence that would convince a jury that the state hasn't proven the case.
How unprecedented is this that someone in such a complex case is representing themselves against prosecutors who have years and years and years of experience in a county like Maricopa?
I've seen, portions of trials where the defendants have represented themselves. I'm only aware of one situation where a defendant represented themselves and seemed to do a pretty good job of doing it, and they did get a not guilty. The case was acquitted. Usually, it's to be polite. It's a train wreck, because what happens is the defendant knows the questions that they want to ask, but they don't know how to put the questions together in a way which are allowed by the rules of evidence. So, for example, when you're watching a TV show or movie about a trial and the lawyers say objection, hearsay, objection, relevance, those rules and how to formulate a question, objection leading, that's something that attorneys can spend years getting good at, getting good at formulating questions and telling that story through questions, because that's essentially what you're doing as a lawyer. You're telling a story by asking witnesses questions, and you're kind of putting the pieces of the story together, and then in your closing argument, the jury should see the entire story. They should go, oh, that's why he asked that question. That's not an easy thing to do. I would say that's even for somebody who's been to law school, new attorneys have a difficult time doing that. That's where as a lawyer, that's where experience becomes valuable, because you go to court and you don't do a great job and you lose, and you learn from that, and you get better and better with these particular skills. For a layperson to just come into court and try to do that, it usually doesn't go well.
It takes so much time, so much repetition to get those muscles down, right? Not just telling the story and asking the questions, but like you mentioned, adding those objections and knowing when and what kind of objection you're bringing up, and then having that exact question, knowing the answer you're going to get from a witness, and that leaves that jury with that aha moment, or wow, good point there. So that's something obviously she's not used to doing. She may be studying case law and knows her case well, but because of that, could we see a lot of delays after the state presents its case and it's up to Lori Vallow Daybell to put her defense on, where we see a lot of sidebars and a lot of just delays there?
We'll see the difficulties even before that, because the state's going to put on witnesses, and then Lori Vallow Daybell is going to cross-examine those witnesses. And cross-examination is, again, it's entertaining to watch actors do it in a TV show or in a movie. But it's another thing to actually do it in real life without a script, in real time, reacting to the way the witness answers the question, because witnesses don't always answer the questions the way you expect them to. So, one of the keys of doing a good cross-examination is being a good listener. You have to listen to what the witness actually says, what their answer to your question is, and then you have to respond to that. And you might have to change course. You might not, you can't write out the script of questions for yourself, because inevitably the witnesses are going to go off the script, and you're going to have to come up with the questions on the fly. So again, it's just not something that's easy to do. And that's a skill that attorneys take years of practice to get good at. And this is a case where it's a serious case and the stakes are high. So it'll be interesting to see how she does. But I would be very surprised if she were able to do an effective job of that. So my expectation is that we're gonna see problems from the very beginning once she starts cross-examining the state's witnesses.
The stakes are high, yet she has nothing to lose. For all the beginners on this case just following, as she was convicted of killing her 2 children in Idaho, and her romantic rival, Tammy Daybell, the first wife of her co-defendant and husband, Chad Daybell, who's been sentenced to death for the same crimes. That was a huge, high-profile case. But just because there was a conviction there, that doesn't mean that Arizona prosecutors have this in the bag. These are totally different cases, these 2 charges against her here, where one of them wasn't at the scene of the crime, and in the other, she wasn't actually the person to pull the trigger on her husband, but she's accused of conspiracy. So there are some nuances there, right?
Some nuances, and the other thing that comes up at a trial are legal issues. So another thing that it's important for the lawyer to do at trial is make a good record of any legal issues. So if the judge makes a legal ruling that the defense doesn't agree with, that there's a good record for the Court of Appeals so that they can review it. And again, this is something that even new lawyers have trouble with this. It takes years to master this, of what you need to say to make a good record, what needs to be presented to make a good record. So you're preserving this issue for appeal, so that an appellate court can look at it and say, yes, there's enough information here for us to determine that the trial court was in error in making this decision, and the conviction should be reversed.
What are the most challenging aspects in defending someone against just pure murder conspiracy?
Usually in these cases, the most challenging aspect is to just get through all of the discovery. So pre-trial, before the trial actually takes place, it's difficult to just get through that. Usually there's just a ton we don't really do paper, anymore. We're not exchanging paper discovery anymore. It's mostly electronic now, but there can be thousands or tens of thousands of pages of documents. There can be hundreds or thousands of photographs. There can be multiple expert witnesses. So just getting through all of the material, getting through all of the witness interviews, listening to all of those recordings, and then coming up with, as a defense attorney, you have to come up with a story that fits the facts, and but explains how your client isn't guilty. That's really the key is, coming up with a story that fits the facts and that explains why your client's not guilty of the offense. And I mean, technically under the law, the defendant isn't required to put forth a defense. The prosecutor has the burden of proof, and they have to prove the case beyond a reasonable doubt. But the reality is that juries expect to hear an explanation as to why the evidence presented by the state isn't proof that the defendant committed crime.
Last thing, Russ, could you see Lori Vallow Daybell as her own defense put herself on the stand to testify on her behalf?
When somebody is representing themselves, anything can happen. Those kinds of trials can be incredibly unpredictable. And, she's going to have to be careful so that she doesn't, if she doesn't intend on testifying, she's going to have to be careful to not testify in the course of, questioning her witnesses, putting on her opening statement. Because if she does essentially testify in those circumstances, even if she's not sitting on the stand, that could open the door to the prosecutor being able to cross-examine her. If she does put herself on the stand, again, it can be very difficult for defendants to do that in a disciplined way. Usually, when I take a case to trial, I spend, depending on the complexity of the trial, if I'm going to have my client testify, I spend a considerable amount of time preparing them to testify. There's a right way to sit. There's a right way to answer the questions. There's, the right demeanor to have. And different cases, it can be different ways of doing that. It's going to be very difficult for her to take the stand herself. And oftentimes what happens in these trials, usually the court does have advisory counsel who's there and available to give the defendant who's representing themselves advice and explain the rules to them and try to keep them on the tracks. But it's not unusual in these kinds of cases for the advisory counsel to be expected to take over when the defendant goes off the rails.
Yeah, I'm trying to imagine her taking the stand and direct questioning to herself. I don't know what's going to happen. I mean, really, Russ, this is going to be one of the most interesting trials and cases, these two trials that will come up for Lori Vallow, just because of the context, the saga behind her, and now representing herself in such a complex case having to do with murder conspiracy. And then the fact that her late brother, Alex Cox, is believed to be the suspected shooter in another case, and obviously the one who shot and killed her former husband, Charles Vallow, in, quote, self-defense. So does she, throw him under the bus and say it was him the whole time in this whole conspiracy case? So a lot to look forward to seeing and how it plays out. Thank you so much for your time.
It should be entertaining. So you're welcome, Justin. Good talking to you.